Once again, good afternoon. My name is Abigail Murat, pronouns she, her, hers, and I am a training and capacity building coordinator for the New York State Coalition Against Domestic Violence. I would like to be the first to welcome everyone today to NYSCADV's 2023 Day of Action Teach-In Series Part 2, Legislation 101. Before we start our presentation today, I would like to go over some housekeeping items. If you have any questions or comments that may come up during the presentation, please utilize the chat box. We will do our best to answer all questions as they come in. If you would like your question read anonymously, please send a direct chat to myself, Abigail Murat, Lauren Pierce, or Esmeralda Pena to clarify that you would like your question or comment read out anonymously. We do have automated captioning that is available today for today's presentation. If you would like to access captions, please click on the closed caption button near the button on your screen and go to the More, select Captions, select a language, and enable the feature. We are recording today's meeting. You can review the recording on NYSCADV's YouTube channel and the 2023 Day of Action. Before introducing our next presenter, I would like to uplift that 2023's Day of Action messaging is largely based on funding issues, updating the DV funding model, contract form, ensuring non-competitive grant opportunities, and living wages. With that said, NYSCADV's policy team has identified these 4 bills as priorities for the day. If you are meeting with your legislators, we ask that you refer to these if it is that it makes sense within your conversation. Without further ado, I would like to introduce Joan Gerhardt, the Director of Public Policy and Advocacy for the New York State Coalition Against Domestic Violence. Joan?
Thank you, Abigail, and thank you, NYSCADV team, for your assistance in facilitating today's Part 2 webinar. We did have our Part 1, the Need to Know webinar on Tuesday, and our third part, which is Rally Like You Know How to Do It, or something like that. It's not exactly right, on Monday at 2:30. All of these, as Abby mentioned, are being recorded, so folks will be able to listen to them on demand. But we are switching up our Day of Action a little bit, particularly because we don't have a state budget yet. So who knows, maybe May 2nd we'll be in the same place we are today. I don't know. But most of our conversation will revolve around funding issues. In the short term, we have the VOCA cuts. We have the issues pertaining to TANF for non-residential domestic violence services. We've been asking for an increase for that for a long time. And of course, the failure of New York State to include domestic violence advocates in any cost of living adjustment or salary adjustments that have occurred thus far. So that was really the subject of our first part on Tuesday. You can review that webinar if you want to take a look again at the messaging. We also, as we've done in years past, will be providing you with loads of materials that will assist you as a participant, as well as materials for you to either leave behind or to send electronically to legislators that discuss these issues. But now, and one other thing too, if you are able to join us in person on Tuesday, May 2nd, and want to meet with your legislators and haven't yet scheduled those meetings, please do so now. We're getting into, it's less than 2 weeks away. Sweat. So we'll get there. We'll be all ready for you. But please make sure you reach out to the schedulers in those offices to schedule meetings. You'll have a window all afternoon from about 1:15 until whenever you choose to end your day for those meetings. So with no further ado, these are the 4 bills that we have identified for priority. We have Kira's Law. We have a bill that relates to reimbursement for shelter housing, which we're referring to as the single differential bill. We have the Fair Access to Victim Compensation bill, and a very new bill introduced this year on coerced debt. And I'll be covering the first 2 bills, and then Brittany Galati, my colleague, will be covering the second 2 bills. So next slide, please. So the first bill, as I mentioned, is Kira's Law. Some folks on the call might be familiar with Kira's Law. NYSCADV has been very involved in the development of this bill and drafting it, as well as engaging with stakeholders to get, the very best thoughts and opinions about the bill, and then working up amendments to the bill. Next slide. Here's a picture of beautiful Kira, who was 28 months when she was murdered by her father during an unsupervised court-ordered visit in 2016. Her mother had been trying to elevate her concerns about the child's safety to the court for many months, but the court didn't take her concerns seriously or just kept punting when they would be willing to hear her concerns until sometime in the future. Since Kira's murder in 2016, 22 more children have been murdered by a parent while their parents have been in court in some fashion, whether it's a divorce, separation, child custody, child visitation. So it's clear that these types of tragedies are not rare and they're not isolated events. Kira's Law, if passed, would require courts to prioritize the safety of children during child custody and visitation proceedings, particularly those involving domestic violence, child abuse, or child sexual abuse. Next slide, please. Kira's Law would require courts to conduct a review of any findings or allegations of child abuse, domestic violence, heightened danger, and risk of lethality before issuing orders of custody or visitation. Just a quick comment here. Those of you who might be familiar with last year's version of Kira's Law, a very important amendment that's been made to the bill is that we're no longer asking the court to hold a new hearing, a special hearing, to hear the allegations. We did hear concerns from the Office of Court Administration that holding such a hearing would crowd dockets. They would need hundreds of more judges. They wouldn't have time to do this, yada, yada, yada. So I see you, Carla. So we have modified the approach to essentially say to the court, look, we're not giving you a timetable for doing this. What we're saying to you is prior to you issuing a temporary order of custody or a final order or anything in between, you need to do this assessment, because we know that they're already seeing these parties in front of them multiple times before they issue these orders. So what the bill says to the court is you need to consider a series of factors. You need to review these, and these are factors like, for those of you who are familiar with lethality factors, they probably sound, familiar to you. In allegations of violence, a history of violence perpetrated by either party, police reports, the use or threats to use a weapon, coercive control has been added to the bill, and there's a great definition for coercive control in the bill. So once the court evaluates all of these factors, then they can issue an order of custody or visitation. And if the court determines that restrictions of a parent's interaction with the child are necessary, then that would be included in the order. Kira's Law would require courts to set forth the reasons for its decision-making on the record and in writing. So this allows either parent to be able to appeal the order or the conditions in that order. And if there's an appeal, Kira's Law defines that that appeal would be heard on an expedited time frame. For final orders in cases involving domestic violence or child abuse, or both, the bill would restrict the court from ordering joint legal custody unless the parties both consent, or where it's been determined that the parties can effectively communicate and make joint decisions concerning the child. So no 50-50, essentially, in these cases. And the bill would create a rebuttable presumption that custody cannot be awarded to a parent who jeopardizes the safety of the child. The bill enhances current training requirements for not only judges, but for referees and other hearing officers who handle child custody proceedings. So before they are able to hear any of these cases, they would be required to complete 30 hours of initial training, 30 hours. The training would be developed and offered by OPDV, NYSCADV, and other nonprofits with expertise in child abuse and gender-based violence in consultation with the Office of Court Administration. Once that 30 hours of training is done and the judicial officer is hearing these types of cases, every year they must undertake an additional 10 hours of continuing education on domestic violence and child abuse. So I don't think I see, oh, there is a question in the chat from Carla. Do they reference the danger assessment tool or instrument that would be used? No, they don't, Carla. So in last year's version of Kira's Law, there was a very clear provision that required development of a tool to assess the risk to the child. There was a working group to be established that would develop that tool. Due to some of the concerns raised about Kira's Law, the prime sponsors of the bill decided to remove the development of that risk assessment tool and put the lethality factors right in the bill. So there's really no need to create an extra tool, since that was a little bit of a hump, I think, to the movement of the bill. And we put the lethality factors right in there. Now, one could argue that it could present challenges in the future as lethality factors change. We'd now have to go back and modify the statute, which could be a hurdle. But at least at this stage, in order to move the bill forward, that's what the prime sponsors decided to do. Great question. Thank you, Carla. Okay, I don't see any other questions just yet in the chat. Feel free to put questions there if you have them. So let's move on to our second bill, which is the single differential bill. Next slide. The domestic violence shelter system was initially set up, as you all know, to provide services to families fleeing domestic violence. The key word there is families. So as a result, most temporary housing units were built to accommodate a parent and one or more children. And the state developed its system to reimburse shelter operators on a per person, per night basis. So for rooms with double occupancy, the shelter gets reimbursed for one bed if one individual occupies the room, or for two beds if two individuals occupy the room. Well, of course, that creates a financial incentive for shelter operators to prioritize sheltering families rather than single adults, because they get double the reimbursement for doing that. And the data bears this out. When we look at data from New York City in 2022, only 24% of the single adults who called the New York City hotline were connected with shelter. Far less, I think it's more like in the 70s, 72, 74% for families who call the hotline. So there's clearly some issues with equity there. The other point I wanted to note is that based on, a 180-day stay for a domestic violence survivor in shelter, which is New York's maximum stay, a domestic violence shelter stands to lose nearly $21,000 for that one unit in its shelter if they house a single individual there. That's what they lose on the second bed. And that quickly translates into hundreds of thousands of dollars, depending on how many units are within that particular shelter. Next slide. So what this bill does is it would require the state to reimburse domestic violence shelters anywhere in the state. This is not limited to New York City, for double occupancy when a room configured for two is used to house a single individual. So whether you have one person in that room or two people in that room, the shelter operator would receive the same reimbursement. This would eliminate the financial incentive that shelters have for sheltering families rather than individuals. And it would make shelter more accessible to all single adults, including already marginalized communities such as LGBTQ+ individuals and older survivors. So this is a fairly basic bill. It does have a financial implication for the state, but we do feel there's some momentum behind this. And it also pulls into the discussion all of the challenges pertaining to the per diem reimbursement and New York's methodology for funding domestic violence services, which we're hoping to elevate with legislators. So with that, okay.
Joan, we have one question in the chat. It's from Carla, and it says, we have 3 bedrooms. Do they stop at the double?
Yeah, so Carla, you have 3 beds in a room. It does stop at double. And we did talk as a coalition about expanding it to multiple occupancy and felt that that would be too high a bridge for the state to agree to because of the financial implication for the double reimbursement or triple reimbursement, essentially. So we decided for first stage, let's get the double in there. And then we can talk to the state about maybe increasing it to 3. Okay, so I'm going to pass it now to Brittany.
Thanks, Joan. Good afternoon, everyone. My name is Brittany Galati. My pronouns are she, her, and I'm the Public Policy Coordinator with the New York State Coalition Against Domestic Violence. So let's move on and talk about fair access to victim compensation. So we know that financial compensation in the aftermath of a crime gives survivors, victims, and their families increased stability while covering costs such as hospital bills, mental health counseling, lock replacement, installation of security systems, and a number of other key issues that crime victims are looking for. From 2018 to 2019, New York State awarded a little over 6,000 victim compensation awards, yet nearly 70,000 violent crimes were reported in that same time frame. So why aren't more victims of crime being awarded compensation funds? Well, our current eligibility requirements in New York State require survivors to report their harm to law enforcement within 1 year of the crime occurring. This doesn't take into account that not all survivors or victims are comfortable interacting with law enforcement. For domestic violence survivors, the time immediately following law enforcement intervention is one of the most dangerous times. Requiring victims of crime to report to law enforcement also disregards the very real safety concerns victims from marginalized communities face when reporting to a system permeated by racism, sexism, heterosexism, ableism, and other forms of oppression. New York's current eligibility requirements leave far too many New Yorkers without the financial support they deserve. Now is the time for an equitable reimbursement system for all victims of crime. So what would fair access to victim compensation do? It would expand eligibility by removing the mandatory requirement to report a crime to law enforcement. It would expand types of documentation a victim can provide to show a qualifying crime occurred. This isn't to say that a crime victim couldn't still provide a report from a criminal justice agency. It just means that if fair access to victim compensation is passed, a victim of crime or survivor could provide an alternative form of evidence, including a written statement from a victim service provider, a statement from a witness to the crime, a statement from the victim attesting to their victimization, a temporary or final order of protection, and a number of other pieces of evidence. This bill would also increase the time frame a victim can report a crime from 1 year to 3 years, which is critical because we know that it takes some time for folks to process trauma. And the longer it takes on someone's healing journey shouldn't impact their ability to access this critical funding. Do you have any questions on fair access to victim compensation? All right, seeing none, we're going to move on to the coerced debt bill. So economic abuse occurs in 99% of domestic violence cases and is one of the primary reasons survivors cite for staying in or returning to an abusive partner. Economic abuse involves maintaining control over financial resources, withholding access to money, sabotaging credit, or attempting to prevent a victim or survivor from working in an effort to create a financial dependence as a means of control. Coerced debt refers to all non-consensual credit-related transaction. Basically, coerced debt can destroy a survivor's credit rating, make it difficult for them to obtain future loans, rent an apartment, or even get a job. Coerced debt can include applying for credit cards, obtaining loans, or opening other financial accounts in a victim's name, forcing a victim to obtain loans, forcing a victim to sign financial documentation, or using threat of physical force to convince victims to make credit-related transactions. Oftentimes, coerced debt occurs without the survivor or victim even knowing that this has happened. So what would the bill do? The coerced debt bill would ensure that survivors are not held liable for coerced debt. It would prohibit creditors from enforcing a consumer debt incurred as a result of fraud, duress, intimidation, identity theft, or other actions. It would also establish a right of action for the survivor victim, the debtor in this case, for relief against creditors for these violations. The debtor must provide a notice of coerced debt to the creditor, including adequate documentation, as well as a notarized statement from the victim or survivor. It would require creditors to cease collection activities and stop reporting the debt to credit reporting agencies if upon investigation they find that the debt is coerced. This bill would provide guidance to consumers, creditors, and debt collectors. It also sets procedures and timelines for disputes, as well as a list of appropriate documentation. So for example, the creditor has 10 business days to report a dispute to the consumer reporting agency once that notice is filed by the survivor victim. They have 30 business days to complete a review of all information. During this time, a creditor cannot directly or indirectly contact individuals accused of causing coerced debt, meaning they cannot contact the person causing harm. They can only use contact information provided in the notice, not any other associated contact information, and they cannot disclose contact information provided by the survivor or victim to any person without express written consent. All of these things are to protect survivors from the person causing harm. The creditor has 5 business days of completing a review to notify the survivor victim of the decision. This bill would also designate coerced debt as a defense to a consumer credit action. And as I said before, it would create a cause of action for creditors to hold abusers liable for the coerced debt. So that is what the coerced debt bill looks like. Do we have any questions on this bill?
No questions in the chat.
Thanks, Lauren. Seeing none, we wanted to provide an opportunity for folks if they have any questions on any of these bills or any of the other areas or topics that may be covered on Day of Action to let us know now. Okay.
Carla, I see your hand is up.
Yeah, I couldn't find my my thing, but off topic here, but relating to something Amanda Anderson said earlier. Amanda, Barbara Turk of Hope's Door is on this Zoom, and she will be heading the delegation up in Albany on May 2. So that's who you two should try to find each other. Amanda noted that she had never been to Albany. If you two can manage to meet up and support each other through the activities that day, that'd be great. Maybe Amanda got called away because she's still offline. Anyway, thanks to everyone at NYSCADV and everyone on the call.
Thanks, Carla. I see one question. What are the bill numbers? So the bill numbers are on each of the starting slides, and we can also provide those numbers in a document that will be available on the 2023 Day of Action webpage that includes all of the bills that we talked about today.
Yes, and in those materials, you'll see each bill with their with the sponsors for those bills. So if you are meeting with a legislator who is sponsoring the bill, it should be on that document so you can thank them. Or if they're not listed as a sponsor, then you can ask them to co-sponsor. But in all cases, you can ask them to talk to the committee chair, and we'll identify which committee the bill is situated in to see if they can put it on an agenda.
Oh, okay. Excuse me.
Keeping you up, Carla?
Oh, gosh, absolutely. But I like the 3-part half hour at a time. I just really like that.
Excellent segue. So we just wanted to mention briefly that the 2023 Day of Action Teach-In Series, this is part 2. We have part 3, Rally Lake Umina on Monday at 2:30, April 23rd. And it'll be consisting of 3 different parts: Rally 101, meeting with legislators and other engagement opportunities, including a dive into the 2023 Day of Action Toolkit. And we also wanted to make sure that folks know that the Teach-In Series Part 1, Need to Know Logistics and DV Funding, was recorded and can be viewed on NYSCADV's YouTube page right now and will be up and running on the Day of Action page when that is live.
All right, thank you all.
All right. As always, we're here to help. Our contact information is on the screen, so if folks have any questions, feel free to reach out to us. And if not, we're really looking forward to seeing folks on May 2nd.
Thank you.